The concept of Sunnah in the Muwatta of Malik ibn Anas, Mohammed Yusuf Guraya, Mcgill University, 1969. Al-Rabi is very explicit and frank in this regard. Wherever he is hard pressed by a Shafi'i, he admits that Malik exercised his arbitrary choice and preferred one scholar of Medina over the others. For example, in this case, Rabi says, "We accept the doctrine of Urwa and reject the doctrine of Ibn al-Musayyib." A Shafi'i has pointed out that al-Amr al-Mujtama' alayhi, according to Malik, was sometimes based merely on the practice of some of the important authorities in Medina, such as Umar ibn Khattab or Umar ibn Abdulaziz. We cannot doubt the truth of such statements of a Shafi'i. We may add to this that Malik was not always bound to stick to Umar ibn Khattab or Umar ibn Abdulaziz. Rather, he wanted authority in particular cases, especially from the great authorities in Medina, but did not regard himself as bound to stick to any of them in case of difference. Nevertheless, it is a very significant statement of Shafi'i that al-Amr al-Mujtama' alayhi was not the general consensus of the scholars of Medina. Rather, it was the agreement of some of the scholars whose opinion or practice was in accordance with the opinion or practice of Malik, or sometimes only the practice of some of the major authorities. Malik held the performance of pilgrimage on behalf of others was not allowed, in addition to the fact that all the hadith which Malik quoted under the subject in the Muwatta from the Prophet are against the doctrine he held. There were major authorities quoted by Malik himself in Medina who held the contrary opinion. The authorities were Ali ibn Abbas, ibn al-Musayyib, ibn Shihab, and Rabi'a ibn Abdurrahman. All these authorities of Malik declare that the performance of pilgrimage on behalf of others was allowed. As Malik did not quote any authority in his own support and opposed all of them, Shafi'i said that, in fact, there was none among the companions of the Prophet who held Malik's opinion. All the scholars of jurisprudence from Medina, Mecca, and from the East and Yaman held that the performance of the pilgrimage on behalf of others was allowed. Malik held that the least amount of dowry in marriage for a woman is 1/4 of a dinar, and this amount is a must. The best evidence Malik could produce in this context in the Muwatta was one hadith from the Prophet, in which the Prophet had given a woman to a person in marriage who could not produce even an iron ring to offer as dowry. Thus the evidence is against the doctrine of Malik. Further, the great authorities of Malik, such as Umar ibn Khattab, Sa'id ibn Musayyib, Rabi'a ibn Abdurrahman, held the opposite opinion and did not agree with him. There was controversy in Medina on the issue of whether wiping on the shoes, al-mash al-khuffayn, apologies, no Arabic, for ablution in winter or in journey was allowed or not. Malik held that it was not allowed for the resident, al-muqim. Here Malik has opposed the authorities in Medina, such as Umar ibn Khattab, Sa'ad ibn Abi Waqas, Abdullah ibn Umar, Anas ibn Malik, Urwa ibn Zubair, and ibn Shihab. Stay tuned for many more parts.